you very much. Mr. McSorley.
Thank you. Thank you very much, Chair, and thank you, Senators, for inviting the International Civil Liberties Monitoring Group to present today regarding Bill C-59. Just as a point of information, last Friday we submitted a more detailed written brief on some of our other concerns. It's being translated and it will be circulated once it has been. Our position on Bill C-59 is that while it brings some important positive changes to the national security landscape, these are being overshadowed due to the government not going far enough to address existing problems, along with the introduction of new laws that raise troubling concerns for civil liberties and human rights in Canada. First, I'd like to focus on the positive. The new review and oversight mechanisms, namely the National Security and Intelligence Review Agency and the Intelligence Commissioner, and ways we can build on these proposed bodies. Dating back to the O'Connor inquiry, the ICLMG has advocated for an overarching review body for Canada's national security agencies and activities. We are glad to see that come into effect with NCIRA. However, we have also learned many lessons from the Security and Intelligence Review Committee's role as
Excuse me, Mr. McSorley, for the purpose of the interpreters, can you just slow down a little bit?
Oh, I'm sorry. Yes, certainly.
Thank you.
Sorry, I'll start that over. However, we have also learned many lessons from the Security and Intelligence Review Committee's role as CSIS watchdog. As NCIRA is largely modeled on the current CSILC legislation, we can look to it for areas of improvement. While NCIRA will have a broader mandate, it will have the same number of members as CSILC. We instead suggest appointing a minimum 5 members, a maximum 8, other than the chair. While the real test may be in the amount of resources allocated to the committee, more members will allow for both the necessary staffing to conduct thorough reviews, and it would also allow NCIRA members to come from a broader range of backgrounds, including from the human rights and civil liberties communities. Next, NCIRA should be limited to Next, NCIRA would be limited to only accepting complaints regarding CSIS, the CSC, and the RCMP. To ensure clear accountability, NCIRA should accept complaints about all national security agencies. At a minimum, this should include the CBSA and Global Affairs Canada. NCIRA should also be granted the power to make binding recommendations based on its findings. Finally, it should also have the power to award compensation, for example, for legal fees, to complainants in cases where abuse was found legitimate. The Intelligence Commissioner is an important new addition to national security oversight. To carry out its work, we believe the IC should be a full-time role. The Commissioner should also be granted the power to place conditions on approved authorizations. And like others, we also believe the Commissioner should play a role in approving active and defensive CSE cyber activities. For both NCIRA and the Intelligence Commissioner, to ensure independence, we believe nominations should be approved by 2/3 of MPs on recommendation of the Governor and Council. While we welcome the new review and oversight bodies, there are areas of C-59 that continue to raise deep concerns. First, it is problematic that C-59 does not respond and rescind more aspects of the Anti-Terrorism Act of 2015, known as Bill C-51. Of primary concern are the threat reduction powers introduced to the CSIS Act in 2015. While Bill C-59 moves to restrict these powers, we have deep reservations about granting active operational powers to intelligence agency, which go beyond those necessary for intelligence gathering. CSIS was created in 1984 in large part to separate the real-world interventions of law enforcement from secret intelligence gathering operations. There is a degree of transparency to the work of that law enforcement agencies carry out. Their goal is to eventually go to trial, where normally their actions would be revealed and the legality of these actions determined. However, CSIS's work does not necessarily lead to an arrest. This means that their operations that do not require warrant, a determination that CSIS would make, would never go to any court. And those that do require a warrant would still rarely, if ever, be subject to public scrutiny or an adversarial process. This includes not just the contents of the warrant, but also how it is eventually carried out. Despite efforts to put in place safeguards, we dispute the necessity of these powers. Our same concerns apply to provisions granting CSIS employees or designated individuals immunity for acts or omissions that would otherwise constitute a crime, and would ask that this section also be removed. In both cases, we see the potential for the grave violation of charter rights and freedoms, with very little information given to justify why such powers are needed. On data collection, we have made multiple recommendations in our brief on concerns about the expansion of CSC and CSIS's powers to collect and retain non-threat related information, such as unselected information and publicly available information. There has been much debate on publicly available information. In regards to the CSC, the definition must be further restricted to exclude hacked or unlawfully divulged information and should also restrict information available for purchase. For CSIS, there is currently no definition of publicly available information in the CSIS Act, raising serious concerns about what they will or won't be allowed to connect. Publicly available information in terms of datasets must be defined. Regarding the disclosure of Canadians' information, we have also proposed further modifications to SCISA or SCIDA, as it's termed in Bill C-59, particularly in narrowing the overly broad definition of activities that undermine the security of Canada, and to ensure there is an actual exception for political activity, dissent, and artistic expression in the Act. At the same time, we once again question why such a sweeping new act was needed in Bill C-51 and continue to urge parliamentarians to repeal SCISA in favor of simpler rules focused on privacy protection. Regarding the no-fly list, we support the call for a redress system and are pleased to see progress on that front. However, this will not address the fundamental flaws underlying the Secure Air Travel Act. We cannot support a tool that operates in secret and does not afford those listed the opportunity to mount an adequate defense. We are willing to discuss modifications to the regime, but maintain our call that SATA must be repealed. There are multiple tools in the criminal code that can achieve a similar goal and which also afford individuals a right to due process in the court of law. Finally, I haven't spoken at length about the CSC Act, although I know I've been speaking at length about other aspects of the bill. The issue is that it's a complex act, and in our brief we do make multiple proposals. However, I would like to add our support to the calls to suspend active cyber powers until further study can be done. At a minimum, we support the call for the Intelligence Commissioner to be given a role in improving any active cyber activities. Thank you very much for paying attention to our concerns and for having us here today.
Thank you very much.